All rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and of the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning, everybody, and welcome to the first session of the Appeals Court in the 2024-2025 term. And you know, we've got a huge group here today, but I'm sure there's just as many people watching on YouTube. So, welcome everybody. It's today your panel is me. I'm Greg Massing. He, him. To my right is Justice Hand. To my left is Justice Smith. For those of you who don't know the rules, it's 15 minutes per side, no rebuttal. Feel free to use your entire 15 minutes, but there's no obligation and no penalty if you finish early. And we have read all of the briefs, so we're prepared. You don't need to spend a lot of time in introduction. Get right to the point. We do have these little tablet devices in front of us, and this is where all the case materials are stored. So if you see us looking at our tablets, it's not that we're looking at the latest election results or anything like that. We're looking at case materials. So I think that's all for preliminaries. And we generally take a break after 3 cases. Today we might wait till after 4 cases, and we'll play that by ear. So the first case that we have today, we have just one party. It's 2023 P237, Mark W. Williamson, trustee, versus Gonzalez and others. Good morning.
Good morning, Justices. May it please the Court, my name is Gregory Assetto, and I represent the Valley View School and Attorney Mark Williamson, the drafter of the trust in question in this case. During the trial, I represented Mr. Williamson as one of the trustees petitioning and responding to the various petitions. As part of the appeal, I now represent the Valley View School because after the trial judge's rulings, their interests became aligned, and I represent both of them for purposes of this appeal.
Is that like is the school run by a board of directors or something? Is that how? It
is, Your Honor. They have a board of trustees, and in this case, the board of trustees of the school appointed the board of trust for the endowment trust, and then the endowment trust controls the SPIVA trust, and it flows backwards to the sole beneficiary of the SPIVA trust is the endowment trust, and the sole beneficiary of the endowment trust is the Valley View School. And so it's important, it's kind of complicated, but it's important to lay that out. It's in the brief, but it's also helpful to hear it in oral argument. This is one of the significant issues, is that the sole beneficiary, qualified beneficiary of the endowment trust was the Valley View School. The other two the other two beneficiaries were not qualified beneficiaries under the MUTC. They were contingent beneficiaries subject to total divestiture, and under the Colecchia ruling, they have no rights under the MUTC until there is a triggering event.
Counsel, could I interrupt you and ask a question?
Please.
What I understand the judgment to be was the judge determined that each of the 2 trustees should be removed.
Yes.
If I understand correctly, what your clients are challenging are the factual findings that were made as a side note to the judge's decision. Is that correct?
That is correct, and I should have said at the outset, and I meant to, that the functional rulings by Judge Moriarty in the probate court have been implemented. Mr. Williamson and Mr. Cushing have been removed as trustees of both the endowment trust and the SPIVA trust. And Ms. Howard, Attorney Howard, has been appointed as the quote-unquote independent trustee, and she serves on both trusts, the SPIVA trust and the endowment trust, as the judge put it in her findings, to oversee and make sure that the trusts are administered properly. So that has been implemented, and you are correct, Justice, that what we're appealing today is really the construct of some of the legal findings by the judge that we view as non-essential, because there were 2 petitions, essentially 2 competing petitions to remove the other trustee, and the judge ruled on that, and getting to that end, she made some findings that we view as non-essential, and we also view as incorrect rulings of law.
So if they're dicta, so to speak, is that what you're saying?
That's what yes.
What's the authority that you can point us to for the removal or the striking or the correction of dicta that doesn't impact Well, let me
So-
leave it at that.
Yeah, so I cited some cases in our brief, Justice, and they talk about, let me just turn to that, I anticipated that question. And a judgment that grants more relief than requested is subject to reversal. That's the Lehman versus Harcon Corp case.
Okay, but did that grant relief? What did the dicta do to grant any relief to any party?
In this case,
Correct.
I think it helped the judge ascertain whether there was conflict between the trustees such that it was harming the administration of the trust, and it got her to the point where she decided it was in the best interest of the trust to remove the trustees. But she did not, for instance, the one area where I view was strongly non-essential was her determination that the endowment trust, as stated, the endowment trust was a permanent fund. There was no need to make that finding. In fact, the judge sort of said at the end of her brief, I probably don't even need to get into this, but since it's become raised an issue, I'm going to rule on it. And so she went on, this is at the very end of the second to the last page of her findings of fact, she went on to say that the endowment trust was a permanent fund, and in the estate planning world that has significance because it means that the trust is going to go on in perpetuity for the benefit of these contingent beneficiaries that Dr. Spiva, the settler, really had no interest in. He just, Mr. Williamson testified, and it's in the record, that he came up with these two beneficiaries so that in the case that the school stopped operating, that the funds would not escheat to the state, that there was a fallback position of charitable institutions that would
Before
receive.
I want to talk about that, but I still want to sort of get sort of these preliminaries out of the way. So,
Yes.
I mean, in terms of the judge's dicta, I mean, isn't that just an interlocutory ruling? Couldn't she reverse herself?
I don't believe so, Judge. This was a final ruling by her.
Well, no, the only ruling, and she said, like you just said, she said it was unnecessary. The only ruling was the removal of the trustees, right? The only judgment that's being appealed here is the removal of the trustees.
No, we're not appealing the removal of the trustees, Judge.
So you're not even appealing the removal of the trustees?
No, we're not. That's what I said, that's not part of the appeal. The trustees have been removed, and the trust is continuing to operate.
So the trustees are now Howard. Are there other trustees as well?
Yes, there are. So the way it was set up by by Attorney Williamson was that the Board of Directors of the school appointed the Board of Trustees of the Endowment Trust. They were appointed before the lawsuit even started.
Okay, so who are they?
They continue to serve, except for Attorney Williamson, who was removed by Judge Moriarty, and Attorney Cushing, who was also removed.
Right. So who are the trustees now?
Attorney Howard is a trustee, Tom Nowak, Bill Carroll, and I believe there's one or two others. But there are other people that are either associated with the school in some way or were appointed by the school to serve as the endowment trustees.
Wouldn't it be useful for us to have the trustee actually here arguing what she thinks the trust should be interpreted? Like, you're arguing on behalf of the school and a removed trustee, and none of the trustees are represented here.
Because I represent the school that is the primary beneficiary of the endowment trust. Attorney Howard would have no standing in it. She was appointed as an independent trustee to make sure that the trust is being administered properly under the rules, under the construct of the trust, but she has no position on this. And the school was a party in the case as well. It's not in the caption, but they were named as interested parties in both petitions, and the school was a petitioner to remove Attorney Cushing under 706B4. There was a proceeding brought by the school as the sole beneficiary of the endowment trust to remove Attorney Cushing as trustee. So they are a party to the...
Can I ask you another, I got you. Can I ask you another preliminary question? Is your client, Attorney Williamson, is he still the personal representative of the Spiva estate?
Yes.
And has the estate been closed?
I don't know the answer to that question yet.
Judge seemed kind of frustrated that it hadn't been closed yet.
Well, again, that was more dicta because it's not in her court. The estate was pending in Worcester Probate Court,
right,
where Dr. Spiva lived and resided. It had absolutely nothing to do with the process other than eventually the estate proceeds funneled into the Spiva Trust, and then the Spiva Trust distributed all the monies to the endowment trust.
So that hasn't happened yet, right? So, right, the endowment trust is kind of empty right now, right?
Well, that was part of the issue, is that this is one of the issues that the judge raised in her findings, that there was a fight between Attorney Cushing and Attorney Williamson as to how much money should be distributed to the endowment trust and when it should be distributed, and such that it never happened. And that was one of the reasons Attorney Howard was appointed, to make sure that this happens.
Right.
So the money, I think you're
so
right.
it's not only dicta, but it's actually talking, it's like talking about future events that haven't happened yet.
To some extent, that's correct, Judge.
And didn't the judge also say, one of the things in her findings was, nobody has moved to reform the trust?
Yes.
And doesn't that sort of indicate she might be open to a motion to reform the trust?
Well, it wouldn't be a motion, it would be a separate petition that would have to be brought.
Okay, but doesn't it sound like she'd be open to it?
Well, yes, but that was part of my presentation, that it's not necessary because the judge made a finding. Part of what I wanted to focus on today is that in that section on the endowment trust, the judge made a finding, and nobody's better situated than the judge in the trial to make this finding, that the donative intent of Dr. Spiva was to leave everything to the school. And so she went on to say, although Article 3 and 4 of the endowment trust is the sole distributor provisions, there should be something to allow the trustees to distribute over and above that to the school. And she said that would not be inconsistent with the donative intent. So based on that, these cases where you're interpreting the trust, the donative intent is the primary concern. And so based on her finding in that regard, she could have determined that the trustees had the authority to make additional distributions over and above Article 4 and 5 of the endowment trust. And that's a part of what we're appealing, because she said that the trust is limited, but then she went on to say that there is no limit based on the donative intent of Spiva, because everybody in his life, from his executive at the school, his estate planning attorney, his nurse, and the office manager and the first trustee of the endowment trust, all said that his sole goal was to provide for the Valley View School. Valley View School was his crowning achievement. He dedicated his life to the school. He founded the school, and his goal in setting up the endowment trust, according to Kim Beatson, the first trustee of the endowment trust, was to ensure the perpetuity of the school. And he wanted no limitations. This was in her testimony in the record, and it's also in our brief, that he wanted no limitation as to what could be provided to the school. For instance, there was a fire at the school, and he wrote out a personal check to repair the building because they had insufficient insurance. He wanted the school to continue. He paid the utilities when they couldn't pay the utility bills. He eliminated the rent. His goal was to ensure the perpetuity of the school. He was not concerned about the continuance of the Pomfret School or the Galapagos.
But Attorney Aceto, if the judge found that the trust document itself wasn't ambiguous and didn't require explanation, so the additional extrinsic evidence of what the donative intent was didn't come into play, which, at least according to the argument that I can see being made, is that that's what she found, that the trust says a certain thing. Then, to Judge Massing's point, the suggestion that there's a possibility that the trust could be reformed to incorporate these other considerations seems to me a logical conclusion to draw, but it doesn't change, does it, the fact that the judge seems to have found that the trust says what it says, that it's not ambiguous?
Well, I don't know that she made that determination. I don't think that that's in her rulings, that it was non-ambiguous. In fact, she described the testimony of all 4 estate planning attorneys that testified, and it's not just ambiguous. The judge can consider parole evidence and the donative intent when there's omitted or missing terms. It's not just whether it's ambiguous or vague. And so she was suggesting that something was omitted, which is the idea that the trustees are not limited to Articles 4 and 5 of the endowment trust. She said that expressly and then didn't make that finding. And so now we're left with having to start another whole action. And part of the problem with all that, and I'm mindful of my time, is that she also made a finding that we had to give notice to contingent beneficiaries of any changes or any intent to distribute to the Valley View School. We had to give notice to contingent beneficiaries, the Galapagos and the Pomfret. And the case law is clear in Massachusetts, and the law is clear under the MUTC, that they are not qualified beneficiaries entitled to notice. The Colecchia case is right on point on this issue, that unless there's the triggering event that's set forth in the trust, they are not qualified beneficiaries. And in this case, the triggering event is not the death of Dr. Spiva. The triggering event in the endowment trust is when the school, the Valley View School, ceases to operate or does not follow its mission. Those are the triggering events that would give the trustees the authority to then terminate the trust and distribute money to the Galapagos and Pomfret. Until one or both of those triggering events occur, they are not qualified beneficiaries. They're not entitled to notice, and they have no authority, no standing to object. And that's under Kalecki and under Markham v. Fay as well. Not a state court case, a federal court case, but nonetheless provides the authority that they are not qualified beneficiaries. And the other construct that I wanted to get to before my time is out is that the judge also found that getting back to what I said about the permanent fund, this is probably the deepest flaw in the trial court's ruling, is that based on just the use of that word endowment in the title of the trust, the judge found that this was a permanent fund. The language, so it's important to understand that the endowment trust is appended to the SPIVA trust. So they were created to be one document with separate trusts, because the endowment trust is a charitable trust and the SPIVA trust was a private trust. And so the idea was that the charitable trust would have certain restrictions, but that it still was appended to the SPIVA trust. And the SPIVA trust specifically says that any titles are not to be relied upon and have no legal weight, that it's actually the provisions in the trust that control. And there is not one provision, not one word in the endowment trust that establishes the endowment trust as a permanent fund. And indeed, the judge concedes that point. But Mr.
She relied on expert witness testimony on that point, didn't she?
There was, I'm sorry, she allow?
She relied on an expert witness testimony as well as the term endowment, correct?
That's true. She relied on Attorney Cushing and Attorney Lichtblau,
right,
that stated that it was a permanent fund. However, she disregarded this testimony of Attorney McCarthy, who was also, there was four so-called experts, if you will, Justice, and Attorney Williamson, who testified contrary to that, that there's no provision in the trust, none whatsoever, that it established it as a permanent fund. And more importantly, considering the donative intent, going back to what I said earlier, that the judge already found that the funds of the trust were to be used for the school, the Valley View School, making this determination that the trust would be, the corpus of the trust would be preserved for these two contingent beneficiaries, is contrary to the donative intent of Dr.
Don't the two
Spiva.
contingent beneficiaries serve the donative intent, because it says that if the school, stops doing the mission as it's supposed to do, then it loses its endowment, and those two contingent beneficiaries get the rest. So isn't keeping them there sort of consistent with a donative intent to make sure the school keeps doing what it's supposed to do?
Well, that's a different issue. I'm talking about down the road. If we try to distribute more money to the Valley View School, we have to give notice to the contingent beneficiaries. You're talking about the process that we implemented to try and remove Attorney Cushing, where we remove the trustees so that we would be the sole beneficiary. That process, it's kind of a moot issue at this point because the trustees are removed. The point of that removal was to get rid of Attorney Cushing, and the judgment.
Could you explain that to me? That was the judge says she said it's undisputed that the contingent beneficiaries were removed so the school could remove Cushing as trustee. How did that work?
So, going back to what I said earlier, our position is that the sole beneficiary, sole qualified beneficiary under the endowment trust was the school. But the Attorney Cushing notified these contingent beneficiaries about the process, and they joined in, and we were trying to remove them so that they wouldn't have any standing in the pending trial court action. We removed them and then took a vote of the school to appoint trustees to the endowment trust, and then the endowment trustees then voted to remove Attorney Cushing from the Spiva trust. So it was kind of a chain reaction from the board of directors of the school to the board of trustees of the endowment trust to the Spiva trust. We were under 706B4, there's a provision that allows for the removal of a trustee, Justice, if all qualified beneficiaries support the removal of the trustee. And so you do the vote as a board of beneficiaries, if you will, to remove him, and then you bring it to the court for approval to remove him. So when we did our petition to remove Attorney Cushing, we also subsequently brought a petition to affirm the removal of him through 706B4.
So, I mean, the way you're presenting that, you clearly would say that it's not bad faith to use the machinations to get rid of the trustee like that. It's a perfectly legitimate thing to do.
Well, I didn't take it in a negative way. The judge has to decide whether it was in good faith or not, because we met all the procedural requirements. And so if she finds it's in good faith, then he's removed. If she determines it was in bad faith, then he's not removed. And so she made a determination at that time that it was in bad faith. Because I think the judge, if I could kind of get into the judge's mind, she thought that the removal of the trust of the other beneficiaries was in bad faith because it wasn't consistent with the donative intent of Dr. Spiva. But again, those issues I'm not really pursuing because the judge already removed Attorney Cushing, and he's gone from both trusts. So that's not really the issue that we're talking about now. It's more about the permanent fund determination, the distributive authority under Article 2 to allow the trustees' discretion to distribute, and the fact that they are not contingent beneficiaries subject to divestiture, are not qualified beneficiaries under the MUTC, and are definitely not entitled to notice or have standing in any kind of proceeding for the trust.
Okay. Any more questions? All right. Thank you, Attorney Cito.
Thank you, Justices.
We'll take it under advisement. Okay. So the second case and the third case today are both DCF cases, and so just for people who are these are impounded cases. We're not to mention that you use any names. So the first of those two is, so you have to identify yourself by number as opposed to by name, is 23P1368, which is Department of Children and Families, I believe, versus Father. Attorney Robin.
Good morning, Your Honors. May it please the Court, my name is Jeremy Robin. I represent the father appellant in this case, child welfare case. The only issue before the Court is post-judgment, post-adoption contact. Let me begin, if I may, with something I think we can agree on, which is the fundamental and constitutional right that a parent has to parent his or her child. That's the natural order of things. Parent parents a child, unless in the extremely small percentage of cases that parent is so woefully deficient that he or she is not able to parent his or her child. That is the smallest percentage of cases, and we've all seen that fact pattern. But even in these rarest of cases, there are circumstances, many circumstances, where a trial judge has the power to allow for some contact in the best interests of the child, such that the child can benefit from a connection with that deficient, woefully deficient parent. Substance abuse issues, mental health issues, domestic violence, etc. Take your pick. Even in those instances, though, post-judgment contact can allow for, again, the very vague phrase that's the case law here, the best interests of the child. So here we have a mother and a father deeply afflicted. Again, take your pick. Substance abuse issues, mental health, domestic violence, poor parenting, current parental unfitness, and termination was appropriate. Neither parent is disputing that. But this trial judge, in spite of the very parallel patterns of current parental unfitness and the reasonable unlikelihood that either parent would be able to be fit in the future, paraphrasing the current state of the law, this judge saw fit to give the mother alone 3 visits a year and denied a request from my client at the trial level to have any post-judgment contact. And again, the afflictions of these two individual parents, very similar. Significant substance abuse issues for the mother.
But isn't the real issue here not their afflictions, but their relationship with the children?
Correct. But I think their afflictions
But I mean,
are relevant to the relationship.
But I mean, are they? It seems to me that the judge's findings in the record here is that your client had very little contact with the children, and in fact, they did not really even enjoy the contact with the father, but that they had better contact with the mother.
That is, I think, what the judge determined.
Right.
But
is that wrong?
I think yes and no. I think yes and no. Both parents had significant limitations. I'm not going to belabor that. But this is a mother who used hard substances in the very latter stages of one of the pregnancies, went months without seeing her children when she was incarcerated and relapsed. Started using substances at a very young age, moved on to the harder stuff by about 18. Her compliance with the service plan was minimal. And I think the lack of engagement in services certainly speaks to an ability to learn mistakes, to acknowledge mistakes, to be ready and able to have a relationship with the child. And incidentally, I want to point this out, with post-judgment and post-adoption contact, it doesn't have to take the form, and it rarely does take the form, of unsupervised visits on a monthly basis. Usually it's, as was the case here, 3 visits a year, 3 hourly visits a year. I mean, that's such a minor amount of contact, such that a child can know his or her parent. Sometimes it can take the form of letter writing. Sometimes it can be a picture. And it's not as if this contact is sort of unsupervised. A letter would be sanitized, would be reviewed for its propriety, et cetera. So to the point of having had bad visits, maybe the contact wouldn't be visits. Maybe it would be letter writing. But this judge,
I'm sorry to interrupt you, but didn't the judge make findings here that the father, even in the supervised visits that he had, was interacting inappropriately with at least one of the children, and that the supervision wasn't the element, it wasn't the critical question, the handling of the contact, it was the father's inability to grasp what was appropriate contact and what wasn't?
That's true. That's true. He's was largely unsuccessful in his grappling with substance abuse issues, and I don't know whether that influenced behavior at that particular juncture, but it certainly might have. I mean, both these parents were in and out of substance abuse programs throughout the pendency of these cases and never successfully dealt with that issue. And I think it affected both of them. And I just want to comment, I read in my sister's brief that she suggested that I somehow am arguing that because they're married and they're together, that because one gets something, the other must also. That's not what I'm saying. What I'm saying, though, is that if mother's going to get 3 visits, and it's very parallel tracks, the same metric has to be used, the same calculus for a father, for some relationship. Maybe it's not the same because maybe the quality of visits wasn't the same. But I don't think we can look at these facts and say, the mother's visits were always great. You know, she always arrived on time. That's not the case. Sadly, it's not the case. There are many parallels with these 2 very sadly afflicted parents.
By the way, just to clarify, the judge ordered for the mother just visitations while DCF has custody, but not post-adoption, right?
Post-judgment, yes.
Post-termination, but not post-adoption.
Correct, that's my understanding.
Okay.
Yes.
I mean, has the adoption gone through yet?
So I don't know the answer to that. I don't think it does, though, until the appeal is completed.
Okay.
Counsel, could I ask one question, just to avoid interrupting you for once?
Sure.
In your brief, you argue that the judge failed to wrestle with difficult facts, but I don't see specifically which facts you think the judge failed to account for.
Again, we're not disputing the termination of parental
Right.
rights. Let me try to answer your question by backing up a little bit. Adoption veto, I think, is the case that needs to be front and center here because that sets the 2-part standard. And admittedly, the first piece, the best interests, it's a very vague phrase. What does that mean? It can mean different things to different people. But I think some of the difficult facts were, I think that there was some evidence that the father did care because when he was incarcerated, he only wanted virtual visits because he didn't want to, have the kids see him in that state. And there were times when he, I think, actually turned down visits while he was trying to get his life together. Again, sadly, he wasn't able to do that in a way that allowed him, I think, legally to ward off the termination of his parental rights. But I think those are some facts that are worthy of consideration. And again, I want to emphasize that contact doesn't have to mean it certainly doesn't mean parenting, but it can be very minimal, a letter or two a year, maybe a supervised hour for Father's Day or a birthday or some event.
Is there anything to prevent him from sending letters?
Yes, I think there is, which is that he's not allowed to have any contact, and the letter would represent a contact.
I mean, the court didn't order that he gets visitations. Is there a restriction? Maybe I'll ask DCF this, but is there really a restriction that he can't send letters to the kid?
I think that would come under the rubric of contact, because in my experience, many open adoption agreements don't allow for any in-person contact. It's just letter writing or pictures. So I think he is prescribed from doing that. Now, the second piece to veto is if it's necessary because the pre-adoptive family hasn't indicated a willingness to allow it. I suppose they could come around and say, yeah, he can write a letter. It would be up to them once the adoption goes through. But my understanding from the record is that they've not allowed for that, any contact in any form. Again, even very minor letter or two that's sanitized, that's
Isn't
reviewed.
there factual finding 168 that the judge made that the pre-adoptive parents are open to involvement of the parents?
I'd have to take a look at that, Your Honor. My understanding is it was only with respect to the mother, but I could be wrong on that.
The judge said parents, and the underlying document said parents. In best interest of the children, how will contact with the father help them ease into adoption?
None of us is trained as a psychiatrist, obviously, but I think we're not wanting in common sense. And for a child to have no contact with a father, to have no knowledge of that father, can engender some confusion. And I think the very minimal contact that my client is asking for, sanitized contact, reviewed contact, would allow for these children to at least know who their father is. Sort of mistakes and all that he's made, which as they get older, certainly they'll appreciate. But I think it's a pretty vague phrase, and post-adoption, post-judgment contact it runs the gamut. So those are the points I want to make.
Okay.
Thank you very much.
Thank you, Attorney Robin. So the department and the children are dividing their time. Department, the first 10 minutes, is that right?
Yep.
Okay. And that's Attorney Gallup.
Yes.
Good morning.
Good morning. May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the decree of the lower court terminating father's parental rights and declining to order post-termination and post-adoption visitation as the judge found it was not in the children's best interest to make such orders. To respond to Justice Massing's question to my brother, finding 168 did address the issue of the pre-adoptive family being open to contact with the parents, and that comes from Exhibit 30, and I can give you the record appendix site if you'd like the specific.
It's in your brief. I found it.
Okay, great. These orders for post-termination, post-adoption contact are for the benefit of the child. And while my brother mentioned that father did care, that's not what the judge is looking at is whether or not continued contact with a biological parent is in the child's best interest, and then also whether an order is necessary to ensure that the child's best interest is maintained.
So it's interesting. So the judge did make the finding about the pre-adoptive parents, but she didn't order any visitation for the mother or father with them. She did while the child's in department's custody, and so I take it the department would be opposed to the father having contact with the child while in the department's custody.
That was the department is supporting the judge's decision. So, what the clinical social worker's opinions are, personally, I don't have that information, and I don't know that it was necessarily apparent from the record. What was apparent from the record was that the two limited visits, father had 2 visits with the children, and both did not go.
Is he allowed to write letters?
I would assume, I mean, to answer that question, I would have to go outside the record. I'm assuming he's allowed to write letters, and given the fact that the pre-adoptive parents said that they were open to contact, I would imagine that they might be open to negotiating something like that once the adoption does go through. Typically, adoptions, we tell, the people not to file anything until an appeal is finalized, so.
I mean, presumably, if he wrote a letter, it would go to the pre-adoptive parent or parents, and they would screen it.
Right. I mean, it would be addressed to.
And if he was abusing that, I'm sure there could be action taken as well.
I'm sorry, I didn't catch that.
If he was abusing that, if he was, sending hundreds of letters and sort of being abusive about it, there's a remedy to that too.
Certainly. And so I think also just looking at the record, given father's ability throughout the course of this case to have contact with the children either in person or virtually, and he did not avail himself of those opportunities for significant periods of time, there's a question in my mind as to whether he would do so moving forward, given an opportunity, but that's neither here nor there. I believe that the judge, applied the correct standard in looking at whether it was in the child's best interest. Now, that involves looking at the relationship between the child and the parent, and, given the fact that the judge determined that the father did not have a significant relationship with either child, there was no order entered. Certainly you can also consider whether the child has formed strong existing bonds with the pre-adoptive family, which both children had. So, I would say that adoption of Vito is a great case. It's very helpful because in that case, the child was in a pre-adoptive home, had made strong connections with the family, and did not need to transition, and so in that case, it was not necessary for an order. Now, Vito is a different situation where the child was not in a pre-adoptive home, and while the child in that case didn't have a strong relationship with the parent, where the child still needed to transition to a more permanent placement, then an order in that case made more sense. If there are no other questions, I would rest on my brief. Thank you.
Thank you. Attorney McKenna?
Good morning, Justices. May it please the Court, Kristen Snyder McKenna for the children. I'm very honored to represent them, and they would ask that you affirm the lower court's decision very quickly. They are very anxious to be adopted by their forever family. And in this case, Your Honor, I know that my brother has been saying that the mother and the father are very similar, and they are in some ways in terms of their issues and their problems that they've had to address. But the mother, in fact, was the primary caretaker for both children, very shortly for the son. But in terms of the daughter, she, along with the father in that first year of life, was the caretaker with him. But then as they struggled with their substance use disorder, the mother did rely upon the great-grandmother in terms of parenting that oldest child. And the great-grandmother was, in fact, the primary caretaker for a long period of time with the assistance of the mother. In terms of the parents, they did have a great deal of domestic violence in their relationship, and from both sides, and neither was able to avail themselves of any domestic violence treatment during the entire pendency of the case. The mother did, in fact, become pregnant by the father again before the end of the care and protection. She was in a program and getting ready to give birth to their third child. During that period, during the testimony at the trial, she did talk about how they were not together, that they are not a couple. and that although they're married, that was not the case. She was looking to co-parent. The reason that this case even became to the attention of the department in 2021 was that there was a serious domestic violence incident between the two of them, where the father, not only in November, had punched the mother in the face in November while she was pregnant, but in January after the child was born, and they were living in the Motel 6, or he was staying with her. She had been the person that had rented the room at the Motel 6. He was staying with her for a period of time after the birth of the child, and he grabbed her by the neck, threw her to the ground, and she retaliated against him. They left the child in the room by himself, and that was the beginning of this case, January of 2021. These children are very lucky to have been placed together. They are very lucky that they've been placed in the same home since January of 2021. They've been with the same loving, pre-adoptive parents since that time, who are initially foster parents, but who have committed to becoming the pre-adoptive parents of these children. They have made sure that these children have received all of the services that they've needed. They've received all the therapy that they've needed. After that first visit with the father, which I believe was in May of 2021, he did not see the children from January until May of 2021. So at that time, after that visit, and he had said some inappropriate things to the daughter, and the social worker was just trying to advise him as to what to say. You know, don't be telling the child that maybe she's chubby and that she needs to lose weight. Things like that was hurtful to the child, to the oldest daughter. And he just wasn't really willing to listen and thought that he knew all the answers. He knew how to parent. He didn't need any advice as to how to do it. And similarly, from that time period, unfortunately, he did struggle with his substance use disorder, and he was in and out of programs. And so virtual visits, well, first of all, he was incarcerated for 9 months because of a domestic violence incident with another woman, not with the mother in this case. And so it was incarcerated for 9 months, did have some virtual time. And then from there, as he struggled with his substance use disorder, going from program to program, he'd start at those virtual visits and then miss virtual visits. And that back and forth of the father was not in the best interest of these children and was harmful to the children over that period of time. And then by the end of 2022, as he was in a program and he seemed to have stabilized, he missed virtual visits. He was an hour late to the Christmas visit that they were going to have, and then missed the visit the following week and relapsed again. So he was in their life, he was out of their life, and that shows us what can happen in the future if there's contact. These pre-adoptive parents had a conversation with the court investigator, very clearly said, the foster mom said that she was open to contact for both parents. They have been doing a great job caring for these children that have been in the department's custody for the past 3 years and 8 months. And if they believe that it's in the best interest of the children, they will make sure that contact happens. The trial judge.
So I think
I'm so sorry.
You're over time now.
I'm so sorry.
I think we can leave it at that. I think we understand your argument.
Thank you.
So, thank you
I
all.
appreciate it.
Well, the case is submitted. It's good for 4 cases. You good for 2 more, Paul? Okay, so we're gonna hear the number 3 case and then number 4 case before we take our break. So the third case is another DCF matter. It's 2024 P39. You took their water. You got your own water over there. It's quite all right. So just hold on a sec.
I've represented so many appellants, appellant children.
Hold on a second, while we get the clock reset.
I'm all set.
No, the clock, we need to reset the clock, just a second. Clerk Levine, I see a 4:42 on my clock, is that, can you, it's at 4:51, or? Take your time. This is a new court year, 15 minutes for for this one. There we go.
You want me to please the court?
Okay, go for it.
Good morning. My name is Svetlana Gervo-Wilson. I represent the mother on this care and protection matter. And my client is asking that the judgment is reversed, the judgment terminating her rights is reversed and remanded both in the issues of current fitness and the best interest of the children. So just to clarify, I have clarified in my brief as well that my client does not object to the finding that she was unfit at the time of trial. As a matter of fact, she actually admitted to it. She lived in a really bad area of Holyoke. There's violence against her. She went into details about how terrible life there had been. And she told the judge, I cannot bring my children there. However, I'm staying in the area for my children because I do not want them to think I've abandoned them. And my plan is to move as soon as these proceedings are over, and the judge at the time did not credit that. She did not believe her that she intends to make any positive changes. And the crux of the judge's findings were that my client does not, she does not trust her judgment. She does not believe that she's willing to change. Now, my client was 23 years old at the time, so I'll give a little timeline. My client moved out of the Holyoke area. She moved 90 miles away to a shelter several days prior to the findings of fact and conclusions of law were issued. And
Was that after the trial concluded?
so that was a month after trial. Shortly after but anyway, I don't want to interject anything that's not on the record by accident, but so what my client takes issue is two things. First,
I didn't catch it. Was it how long after the trial?
a month.
A month. Okay.
Actually, a little over. So July 7th, the trial, the matter was taken under advisement, and August 18th, her rights were terminated, and August 12th. So it's a month and several days.
And then when did she file the motion?
And she filed a 60B motion, and in the meantime, she had a baby. She was parenting the baby successfully.
So when did she file the motion then in that timeline?
So she filed the motion quite a bit after. It's almost a year after, and the reason was, the honors, that she did not have counsel for quite a long period of time. And she did have a baby at the time, and that was one of the reasons that she said, well, if I can parent a newborn, why can't I parent my other two children? The judge did not, so the two things that my client takes issue with, and that she believes that are abuse of discretion. First, the best interest of the children. The judge deciding to terminate my client's rights and approving the adoption plan the department had proposed for the children to be adopted by a foster parent who was not related to them, versus my client's proposition was to find her unfit, which she agreed to at the time, and allow her stepmother's guardianship of the children. And her plan was, I will get better, let my stepmom have my children in the meantime with her other biological children, and until I get myself together so I can have my children all together. Well, the judge didn't like that. And why is that my apologies. Why is that abuse of discretion? Well, it is true that the judge does not have to give any undue weight to the parent's proposed plan. However, it is not disputable also that DCF has obligation to keep families together. They have to vet family members who are willing to take a child on prior to any unrelated person. And it is true that children had been living with that person for a while at the time of trial. However, and the judge found that that person had a higher level of attachment than grandma. However, adoption of Rona says if that is the attachment the bonding between the child and a alternate caregiver is dispositive, parents are never going to win because, of course, they'll bond with the person they're living with. The issue my client is taking that the client did not even handily consider both plans, both permanency plans. She mentioned nothing about what benefits would the children have if they live with their grandmother.
Something the way you described that troubled me a little bit. You said that she wanted it the kids to go with her stepmother,
Yes.
so that when she got better, she could go back and become the parent again.
So she
Isn't
wanted
that
to
sort-
be.
Is that, I mean...
I might not have expressed myself clear enough. So she's only found to be unfit, but her rights are not terminated. Every 6 months, she has the right to review and termination. She needs to claim that she has changed her circumstances, such as that she's now fit, and the judge and the DCF then has to prove that she's still unfit. In this case, when her rights are terminated, this is final. She can never go back and request review of her parenting qualities, parenting abilities, because the judgment is final. And that is what my client takes issue with. First, first abuse of discretion, why there is an error, is the judge determined it was in the children's best interest to be adopted by an unrelated person without considering her proposal, the guardianships that my client proposed. I mean, yeah, she did mention the guardianships filed, but she said, and she mentioned nothing about the benefits for the child if placed there. And I know that DCF takes issue with that footnote that I mentioned, that there is research in that in the area of children's best interest, and why is it in best interest of the child to be with family? I'm not asking
have that
you.
research before?
So the judge did not, however, and that's why I'm not asking you to click on those links and look into it. But the judge also does have obligation to be familiar with the subject matter of which he's presiding, and I know I'm in front of this judge all the time. She's a wonderful judge, but I think in this particular case, she kind of stuck with the status quo a little bit. I mean, she found that the children were doing well where they were, and my client does not object to that. The children were doing well where they were. However, she submits that they would have been doing fine with her grandmother also, with her mother also, stepmother, my apologies. Now, there's ample evidence that grandma was great with the kids. She had visits, they were going to her, she didn't even have to bring them any presents. They would still cuddle with her and go on the floor and play. There was really no real reason to deny those guardianships, other than the fact that the children were not placed with grandma, which my client had no control over.
Well, I mean, the judge gave several reasons why she didn't like that placement.
She did mention several things. So she mentions DCF history from many years ago, which there was no evidence presented as to, there's no documents that my client could have used to rebut. I mean, she didn't have the opportunity to question any of those social workers on the prior case because that evidence wasn't produced. It was only mentioned. There was a case, there was never CNP filed. The children were never removed from the mother. Another thing she mentioned is that my client's stepmother had too many children in the house. She had several children. Most of them were older teenagers at the time. However, those are just not good enough reasons.
Wasn't that, indeed, at the beginning, didn't your client also say that she didn't think that it was a good placement because the stepmother had too many other kids?
So that was, yes, that was at the very beginning of the case, but from the get-go, she just didn't, she didn't want that. I mean, but she did change her mind at the time because at the time when she said that her stepmom has too many kids, she was hoping to get the kids back. So it was between her and her mom, and not between her stepmom and a stranger. The other error, so this is my client's main concern, is why didn't the judge approve the guardianship plan versus termination of parental rights? The other issue is the 60B motion. Now, my client agrees that at the time of trial, the judge had enough reason to believe she was not going to change. And that's what I told the judge in the 60B hearing. The transcript is in the record. I told her, at the time, you had reasons to believe that, but you're wrong. And this is why you're wrong. This mom moved, as she said she would. She removed herself from all those negative circumstances that she had been in. And she was parenting a baby, and there was a person who was actually able to, it was the program director who wanted to testify. She submitted affidavit stating what a good parent my client is. In the meantime, DCF was not giving her the court-ordered visits. She hadn't seen the children in quite a while. She was anxious to introduce the baby to the two girls. And the judge said that she denied the 60B motion, stating that mother's living circumstances were not the only reason why she terminated the rights. And she mentioned marijuana use. However, under the adoption of Catherine, there must be a nexus between any use of any substance and the ability to parent. And there was absolutely not a shred of evidence the mother was ever, her mental state was altered by the use of marijuana. I mean, the judge made several findings about her usage, and my client did admit that she was using, but nobody said that, and excuse my colloquialism, but nobody ever saw her high, especially when parenting the children.
Counsel, wasn't there an issue for the judge, both at the underlying trial and on the 60B motion, about the mother's ability to appreciate the significance of things like domestic violence, so that removing yourself from the circumstance, and credit to the mother for that and for her parenting of the youngest child, but the judge's issue wasn't necessarily an issue-by-issue assessment. It was an assessment globally of what the mother's presentation was, correct?
Well, her assessment, it included multiple things. She said the living circumstances were one, she didn't trust her judgment, but how else can she prove her wrong by proving her wrong by removing herself from the circumstances? I mean, this is the first step that she needs to take. And at the time she filed the 60B motion, she wasn't in a violent relationship, she wasn't in Holyoke, surrounded by multiple crimes, and the last person that had abused her was actually murdered. I mean, it is really scary, and she admitted even in trial, she said, I'm afraid for my life. She was a cooperating witness in murder investigation as a witness, not as a, not as a suspect. So she was worried, and that's why she didn't want the kids there. But so to question her judgment, I understand the judge questioning her judgment, but how do you change your mind? Other than by removing yourself from the circumstances, and she took domestic violence classes, she was in therapy throughout the whole proceedings. So that is the best that she could have done under the circumstances. What else could she do to change the judge's mind? Similar with the mental health. I mean, so on the adoption of Quentin, it's not only enough to state that the parent is mentally impaired, but you still need connection between that mental health disability or diagnosis and the ability to parent the child. And there really isn't any. Nobody had described her acting out or doing anything that would be considered unparently. So that element is also lacking. The judge also mentioned criminal activity. However, there's no, mother had no convictions whatsoever at the time. So I'm not quite sure this could have been even considered like, I mean, if she did have convictions, she might have become unavailable, but this was not the case in her particular case.
Did she have open charges at the time of the motion hearing? Or just at trial?
I'm trying to remember because, and I'm afraid I might say something that did not happen in 60B motion. But at the time of trial, she didn't have any convictions, and at the time of 60B, she was not convicted of anything. And she was doing fine. And the child, I didn't mention that the child that she gave birth to, that she was parenting, when she filed the 60B motion, she offered guardianship to her stepmother. Because she was worried about DCF taking her as well. Even though she had parented for about 6 months, she was not removed. DCF was visiting her in the program, but she became nervous, and as she said, I mean, I'm not expanding the record, it was in the 60B motion.
Also, in the judge's legal conclusion 6, she referenced that your client had been incarcerated for selling drugs. You're saying she wasn't convicted, or you're saying that finding or that conclusion is erroneous? So that she was convicted, I'm trying to, so it was nothing at the time that she was going to do time, she was not convicted of any crime at the time of that would expose her to incarceration at the time of the trial, is what I'm referring to. As to conviction of selling drugs, I'm so sorry, my memory is failing me. I do not recall if she was, but I know that she wasn't in danger of that at the time of trial, in the danger of becoming unavailable. And even then, even if she had been convicted, if she had a plan for care of the children, that would have still not been sufficient to terminate based on that alone, based on her unavailability. And again, Your Honors, my client is asking the judgment is reversed and remanded for a new trial on current unfitness and best interest, and I will rest on my brief. Thank you.
Okay. Thank you. We'll hear from the department and from the children.
Good morning, Your Honors.
You can bend it up. You can. Yeah.
Okay. May it please the court, my name is Claire Gilchrist. I represent the Department of Children and Families in this appeal. If I may, just like to briefly address my motion to strike. If there are no questions, I rest on my motion.
So what did you moved to strike because this was not raised below, right? I mean, that's
Correct.
essentially.
That's correct, Your Honor.
So there was no objection, no argument at all below about there being, the preference for kinship placements?
That's correct, Your Honor.
Is there?
Yes, so the department's regulations require it to prioritize kin as long as it's in the children's best interest when they're looking at placement. And that's exactly what the department did here. They looked at a number of relatives, including paternal grandparents, the step-grandmother, and a paternal aunt in Florida. In fact, they were still assessing that paternal aunt in Florida, so they were doing exactly what the regulations required them to do.
Counsel for the mother said something about, there are some cases that say you're not supposed to consider how well the child is doing in the new placement, but isn't that vis-a-vis the parent and not vis-a-vis other placements? I mean, it seems like it's not fair game to say, well, the kids, they're not great with their current parents. They'd be much better with adoptive parents. You can't do that. But maybe you can say they're doing really well with these pre-adoptive parents. That's better than the plan that's offered by.
Certainly, and that is the judge's job. The job that the trial court judge has to weigh the plans and meaningfully evaluate them. And here the judge did that. She made 35 findings of fact, roughly half to each plan. So she did meaningfully consider, and she was really primarily concerned with the adequacy of the care that each caregiver could provide. So, while she did mention bonding, that was just one of the components that she looked at. And as my sister does acknowledge in her brief, that is a factor to consider. But as you can see from the findings 181 through 216, the judge was very concerned with the quality of the care that the children could receive with Ms. F., the step-grandmother. And she really didn't find her to be credible in her testimony, and she found her to be evasive when discussing these pretty significant matters, such as the 3651A reports that had been filed. So there were mandated reporters who clearly were concerned with the step-grandmother's care of her own children, and the step-grandmother was not adequately able to address those concerns in front of the judge. And the judge, that was her discretion and her entitlement to evaluate that witness testimony. There's a lot of deference that this court affords a trial judge in their assessment of witnesses.
Were there witnesses about other than Ms. F? That's who it is, right? Yeah. Were there witnesses about her prior history, or was it just just cross-examination of her?
So,
and specifically, I'm asking because Attorney Jerova Wilson said she didn't have an opportunity to cross-examine the prior findings of things that had happened to Ms. F. in the past.
So there were department social workers who testified, but they were not the social workers who were involved in investigating the 51A reports that had been filed against Ms. F. So the judge was really relying on the manner in which Ms. F. discussed that history and observed, her testimony and found her to be evasive in discussing that history, and that was of serious concern to the judge, particularly because the allegations were specific around her, not putting in therapeutic services for an older child, and another child missing significant amount of school, and the judge just didn't find Ms. F. credible regarding those points. Your Honor, the department is asking you to affirm the orders of the lower court today. The juvenile court made 216 uncontested findings of fact that are supported by the evidence in the record. And, you know, this is really difficult circumstances, this case, really sad circumstances. But unfortunately, over the 2.5 years of the duration of the case, mother was unable to remedy the many dangers to which her actions exposed the children. And she also was still minimizing the impact of that on the children on the last day of trial. Furthermore, here the judge did everything that she was required to do in assessing the adoption, the competing permanency plans. She approved the plan of adoption of the children by their current foster parent because she found that it was in the children's best interest. That is the standard here, adoption of Hugo. And there's no requirement for a judge to find that a parental nomination of kin, that kin is somehow unfit before they can approve an alternate plan. Both plans can pass muster. We know that from adoption of Dora, which is based on adoption of Hugo. So there's no requirement that one plan be unacceptable, basically. And so I think mother here misstates the law in her brief where she states that there was such a requirement. Turning to the 60B motion, again, mother, claims that the judgment should be vacated and there should be a new trial because she changed her housing. She moved away from Holyoke and Springfield. That was a really positive action that mother took. However, there were many factors the judge relied on in finding mother unfit, and mother had not remedied those other factors. What was of particular concern to the judge was mother's insight into the domestic violence and how to identify unhealthy relationships. And mother doesn't claim in her 60B motion to have addressed that issue. She hasn't done the counseling work to be able to identify and prevent these unhealthy relationships, which are so detrimental to the children. And of course, mother doesn't claim to have stopped her marijuana use, which here is relevant and there is a nexus to her care. When she did have the children in her care, the evidence was that she was using marijuana several times a day. She was using it in the room next to where the children were, and during that time, she was neglecting the children's medical care, and the children weren't being properly fed. So there is a nexus there.
You think the evidence is strong enough to draw that nexus between marijuana usage and her inability to meet those obligations?
Yes, Your Honor, I do. I think it is strong evidence here. There clearly was neglect of the children during the time period that mother was using marijuana throughout the day, and including exposing the children directly to the marijuana smoke in the apartment. She was using the kitchen, they were in the room next door. She also exposed child 2 in utero to her marijuana use. So yes, the children were directly impacted there in terms of basic care of feeding.
Again, I think a judge could take judicial notice of a child exposed of alcohol, excessive alcohol, or opiates, things like that. But are we at a point where a judge can take notice that use of marijuana during a pregnancy is harmful to the fetus?
Well, in this case, there wasn't judicial notice needed because mother's OBGYN reported that there was risk to the child of low birth weight and had discussed that with mother, and mother acknowledged that she was aware of that risk and continued to use marijuana anyway. Your Honor, turning back to the 60B motion, there was also, Your Honor's mentioned these criminal charges. Mother did not claim in her motion to have resolved any of those. She had open criminal charges for firearms violations at the time of trial. She doesn't mention anything about whether and how those have been resolved. So while it is commendable that mom did make these changes, it doesn't constitute extraordinary circumstances. In cases where this court has found extraordinary circumstances and remanded a case, for example, adoption of Theodore, adoption of Cesar, In those situations, the parent had cured all the deficits that a judge relied upon to find them unfit. And that's not the situation here. And furthermore, in those cases, the pre-adoptive placement had disrupted. And so those are the extraordinary circumstances that we would be looking at, and they're not present here.
Okay.
There are no further questions, I rest. Thank you.
Thank you. And we'll hear from Attorney Krasner.
May it please the court, I'm Sherry Krasner on behalf of the two children. Mother surely is entitled to a full and fair process because of the right that is at stake. I ask, however, as this court deliberates what to do and the speed at which to do it, to remember that my older client was born in December of 2018, came into care in January of 2020, and has been in her current placement since February of 2020. Her baby sister, born in December of 2019, came into care at only a few weeks old, has been was placed with her sister in August of 2020. They deserve to have finality now. They're doing very well in their placement, as the court notes in findings 210 to 214. They're attached to their foster mother. She meets all their needs. But of course, as Justice Messing pointed out, that's not the issue. The issue is we wouldn't get to that issue if mother was currently fit and able to meet the best interests of the children. But she surely is not. The department put on a very convincing case that mother's many parental deficiencies made her unable to meet the best interests of the children. And again, as Justice Hand pointed out, it was that inability for mother to recognize just how much her actions had and could place these children at risk. And again, I would point to findings 80 to 82 and conclusions of law 6 through 9 and 19, and also the case adoption of Sicily. This idea that if a parent doesn't recognize what he or she is doing wrong, then they're never going to be in a position to change it. And sadly, that was the circumstance here. With respect to the adoption plans, and even if this court found the argument made by Mother's Counsel persuasive about the errors that, about a different way to look at the adoption plan, that's not the issue. The issue is, did the judge abuse her discretion? And she explains very clearly why she made the decision that she made the decision. And I think it's very important for the court to remember also that the guardian has not appealed, or there's no record evidence, the guardian appealed the decision to deny her guardianship petition. And we know from guardianship of Tara that if the guardian, or the potential guardian, is unwilling to take the children at this point, that no court would be in a position to force her to take the children. So we can't go anywhere with that issue. That issue is foreclosed by the fact that the guardian has not appealed the decision. With respect to the 60B motion, as I point out in my brief, it's somewhat confusing, the theory that Mother is making her argument. She talks about appealing both under Section 60B-5 and under 60B-6, but 60B-6 is that catch-all if, in fact, none of the other factors 1 through 5 apply. So it's somewhat unclear, the theory on which she is proceeding, but I would say under 60B-5, and she relies in that case on adoption of Theodore, that the facts of that case are so different from the facts of this case, as my sister pointed out, in terms of the fact that the judge in Theodore had identified one deficiency, that mother needed to separate from her father. That was the one thing that was holding her, her back. And she did that, plus the children in Theodore were not in an identified placement. So I would say that the cases are so factually different that relying on 60B5 doesn't, and Theodore doesn't apply in this case. And with respect to 60B6, the extraordinary circumstances, and those, although, again, commendable that mother had changed her living situations, surely not sufficient to open up a brand-new case where the children are in a safe and secure placement, and it's not clear that mother has met the other deficiencies and not even recognized the other deficiencies. I see that I have 3 seconds left, so I'll rest on my brief, and I thank the court for its attention.
Thank you very much. Thank you all. The case is submitted. So we're going to hear one more before our typical morning recess, and that would be 23P 1103 McClellan versus White Cliffs Condominium 4 Association. Attorney Jacobs, what's on your tie?
My grandchildren, Your Honor.
It's hard to see from here, but...
This is when my one grandson was coming to the appellate court for an oral argument here.
Oh, no kidding.
Last year. If it please the court, Walter Jacobs for Mary McClellan. This case involves an issue of discrimination and retaliation of a condominium owner by the condominium association. The issues that I think are important for the court to address will be the definition of contiguously located housing. It is our position that condominiums, which I think are undisputed, are included under the protections of Chapter 151B, come in under the definition of contiguously located housing. The trial court indicated that this property was not under the definition of contiguously located housing because the association had not sold, rented, or leased 10 units in the condominium complex. There are 108 condominiums that are contiguously located within White Cliffs Drive. There are multiple buildings, 108 units. There are 12 fourplexes and 10 sixplex buildings, totaling 108 units. We believe that all those units in that area constitute contiguously located housing. The trial court indicated that because the condo association didn't own 10 or more, it did not meet the definition. We believe the definition goes back to the declarant of the condominium, Capeside. When Capeside Development developed this property, it owned all of the condominium units. We have in the stipulated facts, we've indicated that that is true.
But can I ask you just to look
Yes,
at
Your Honor.
addressing the definition? Housing which is offered for sale, lease, or rental by a person who owns or at any time is owned. So the statute itself, it has language about at any time has owned, and it didn't use, it doesn't begin by saying housing which at any time was offered for sale. It says which is offered for sale, which seems to, I mean, why isn't that saying that we're talking about a current owner?
I agree that the exact wording of the statute is awkward in the context.
You could say that again, though.
Well, I think that's part of the problem in interpreting and understanding. The statute is not as clear as it could have been written, because if condominiums are to be protected, as the MCAD regulations 804 CMR 2 indicate that condominiums and associations, Chapter 151B indicates that a condom association is a person under Chapter 151B. The regulations of MCAD indicate that homeowners associations are covered entities under Chapter 151B. Where do condominiums then fall within the 151B statute? If they don't fall under contiguously located housing, where do they fall? What are their protections? How are condominium owners protected vis-a-vis the association that owns the common space? It would have to be under, I believe.
They're protected. They can't discriminate.
Well,
right. I mean, we're only talking about we're not talking about whether condo associations are included. We're talking about whether they are on the hook for paying for accommodations.
That is correct. Section 6 and subsection 6 and 7 of 4, which indicates the prohibitions, indicates that it has prohibitions with regard to rent, lease, and sale, which is what the trial judge focused on. But the B subsection of 6 and 7 talks about discrimination with respect to any term, condition, or privilege of the owners of the condominium. The question, Your Honor, is correct. So under 7A, does the condominium association have to pay for the accommodations that are requested? It does have to pay if this meets contiguously located housing. Kakovich versus Halcyon Hill, which is a case decided by MCAD, addressed this very issue and found that the condominium association is covered under Chapter 151B, and that because the trust, all the condominiums in Halcyon Hill were owned at one point in time by the declarant, therefore it was contiguously located housing of 10 or more units, and therefore the condominium association had to pay for the accommodation that was requested. Kakovich requested, I believe it was a ramping, and the MCAD ruled that they had to pay for that ramping of 5 or less steps because it was contiguously located housing, because it felt it met the definition of at one point in time was owned and controlled by one individual, being the declarant of the condominium.
Well, I mean, the judge in his ruling said that actually the MCAD in that decision didn't really address the issue of whether of ownership. But I do want to let's address the issue of ownership. I'm turning to 7A1 and the proviso about who has to pay. Assuming it's contiguously located housing, reasonable modification shall be at the expense of the owner or other person who have a right of ownership. And so you have to convince us that the condo association is the owner.
The condo association is by the declaration, the master deed. The condo association owns the common space. The patio is common space under the master deed.
The other tenants own, the other condo owners own the common space.
The association is the representative of the members of the association.
Right.
They are represented by, they form the association. They all own an undivided interest in all the common space. All the owners together as an association of homeowners. They own the common space. The patio is an exclusive use common space dedicated to each of the individual owners of a first floor unit, a ground floor unit. So what was being done at the time in this particular complex, they decided to redo all of the patios in the entire complex. They were doing an envelope project on the exterior, windows, doors, siding of the property. They were doing driveways, landscaping, and they were doing all the patios over. When this property was built, because of the topography of the land, a lot of these patios were built as split level. And the inside of the condominium is split level, where the dining room is at one level, the living room is 4 or 5 steps down at a sunken level.
Can I ask you actually to help me clarify on that? So there's exhibits, there's a picture, I think it's a before, I think we've got before and after pictures.
That's correct, Your Honor.
Right, so is the one, this one here with the railing, is that the before picture?
I believe that is a before picture.
1281?
And that is a split level, I believe, Your Honor.
Right, there's higher patio up here and there's lower
That is
down
correct.
there. And then after picture,
that is
same
the
level.
granite that was done after the renovation work was done. They were doing renovation.
Right, and what your client is asking for is just rails here?
What my client was asking for was, because she was 90 years old and having mobility issues and was going to a rolling walker, she could not properly exit her unit if she had to navigate steps with a rolling walker. She wanted the condominium to bring, when they did the renovation of the patio, she wanted them to bring it up so it was almost level with the threshold, maybe a half inch less maybe a little space between the building and the condominium so that water wouldn't drain in, proper sloping of the patio, but she would be able to wheel her walker out onto her upper level patio from her dining room, and she would be able to take her walker out and then reach back into her dining room to take a glass of lemonade or whatever out onto her patio, whereas if she has steps, she has to hold on to that walker, and it became very dangerous for her to navigate those steps in exiting her condominium.
So a ramp wouldn't be good enough, handrails wouldn't be good enough, you actually need to raise, she actually wanted them to raise the patio?
They were ripping down all the patios in the whole complex. She asked them, instead of lowering, her patio was split level, so it was just a little bit low. She asked them, instead of lowering it down 2 steps, just bring it up a little bit on the upper level and do the same, because she needed the accommodation now of not being able to walk out as readily because she had a rolling walker. She had to use both hands on to move the walker and support her balance at the same time.
I'll ask another historical question too here. So this before picture here with the railing, is this the 2010, 2011 accommodation?
This is an accommodation she had because there originally were railroad ties going from the original condominium construction, and she needed to have steps that were more secure, and she wanted railings to be able to hold on to at that point in time.
Did the association pay for those?
They gave her an accommodation. At that time, I believe she paid for the cost because the cost was minimal. She made additional requests because there was drainage from a downspout coming on, allowing water to come onto her patio, allowing mold and slime to grow on the patio, which made it very dangerous for her as far as a slip and fall. And because they were redoing all the patios anyway, she asked to raise hers up so it would be easier for the wheeled walker, the rolling walker, to wheel out from the dining room onto the patio from that level, and then from the living room, which was the lower level, be able to do the same, and then they could create a ramp between the upper and the lower level so she could go outside and connect between them. That never got to any stage of finality because although the condominium association said they would hold discussions, they would talk to her, they just ignored all of her requests. They never made responses. As indicated in the brief, there were several emails and letters sent by my client and by her daughter saying, look, respond please to my request for accommodations, and they just didn't respond. They said, we'll get back to you, and did nothing.
We'll get back to the statute. I mean, I thank you for, I did need you to clarify the facts, but, so both in 4 subsection 6 and 7, which precedes 7A, they talk about, it's a discriminatory practice. 6 begins for an owner, lessee, sublessee, licensed real estate broker, other person having a right of ownership, and then way down at the bottom, or any organization of unit owners.
Correct.
So it seems to me, and the same language is repeated at the beginning of 7. So at the beginning, they're distinguishing between an owner, a person with a right of ownership, and an organization of unit owners. Those seem to be 3 different entities according to the preamble part. But and then so that in 7A1, it talks only about owners and persons with right of ownerships.
It describes in 7A1 what discrimination consists of, and it talks about refusal to permit or make, and in this case at the expense of the handicapped, unless it is continuously located housing of 10 or more units, shall be at the expense of the owner or the person having right of ownership.
But
now here,
it doesn't say or condo association or lessor or.
it does not, and I can't explain the absence there of that, except to say that in the regulations, MCAD indicates that condominiums and condominium associations have requirement. They are included under the requirements and the protections of Chapter 151B.
Of course, the regs also say that a continuously located housing is a building with 10 units. Right?
Pardon me, Your Honor?
The regulations also say that contiguously located housing actually or it says that the owner has to pay to make accommodations in a building that has 10 or more units. It's at the very last page of your brief. Reasonable accommodations, 2023. It's actually second to last page. Under subsection 3. Under state law, if the dwelling is in a building with 10 or more units, or is publicly assisting housing, the owner must pay reasonable accommodations. It doesn't say, it says a building. It doesn't say.
Which page are you referring to, Your Honor?
It's the second to last page of your addendum, 112.
On my brief?
Yep.
Page 52, 51?
Well, it's the second to last page. It's the MCAD, it's the CMRs. It's under paragraph subsection, it's 2033.
I'm having difficulty finding it, Your Honor. The last few pages talk about the Kakovich case. They are quotation from Kakovich.
No, the addendum.
The addendum.
Yeah, like the
I'm
second,
sorry.
yeah.
Addendum D?
The second to last page that you, of the document. It's really, we really don't need to spend this much time on it.
You're talking about the CMR regulations, Your Honor?
Yeah.
Which number regulation?
2033. Reasonable accommodations and modifications.
Correct.
And
the owner.
This is sort of, they're paraphrasing what contiguous housing is, and it talks about if a dwelling is in a building with 10 or more units. So why isn't,
I think that regulation is true and correct, Your Honor. I see exactly what you're referring to. If there is a building of 10 or more units, then the owner has to pay for it.
Right.
In the condominium structure where you have multiple buildings, the phrase contiguously located housing is to encompass all those buildings as if it were one building of 10 or more units, if those contiguously located buildings comprise more than 10 units. That's the whole purpose of defining, I think, contiguously located housing differently. No one disputes that if the building, a single building, had 10 or more units, the owner would be required to do it. Here, the common space is owned by the association. So contiguously located housing, it takes into account all the separate buildings, which is how many condominiums are built and structured. There are smaller numbers of units in each building. These were 6-plex and 4-plex, so they wouldn't qualify under the requirement that it be 10 or more units per building, but it does qualify under contiguously located housing because you take into account all of those units together, and that's how a condominium protects a large-scale condominium, because the scale, the assumption in the statute is if you have a 2 or 3 family unit, it would be perhaps an undue burden to expect the condo association to make an expensive accommodation for one member in a 2-unit or a 3-unit building. But if you have 10 or more units, it's an economy of scale. In this case, you have 108 units, and you have a condominium association that was already tearing down these units and making accommodation. At the
moving from assumptions to literal language of the statute, in certain subsections, the legislature did use condominium ownership as well as contiguously located property. So they know the difference. For instance, in subsection 6 and subsection 11, again, the statute states both contiguously located housing accommodations or organizations of unit owner or condominium or housing cooperative. But they didn't include that condominium or housing cooperative in 7A.
That is correct, Your Honor. 7A doesn't mention that specifically. It just
So wouldn't they have
references.
mentioned it if they wanted to include condominiums?
Unless they assume that contiguously located housing applies to more than 10 units in a contiguously located housing complex, if they wanted to refer to it that way. They could have referred to it as condominium, but what if the condominium is only 3 units? If they put the word condominium in, it would change the context, because if the condominium were 2 or 3 units, you wouldn't be requiring the common space accommodation to be paid by the association. But if it's contiguously located of more than 10 units, you're getting back to requiring the economy of scale. It has to be 10 units. It's either a building of 10 units or contiguously located housing that equals more than 10 or more units. That way you're not forcing a condominium, which if they put condominium or condominium association, then would that not imply that a condominium association of only 3 units or 2 units would have to pay for it? That would mean in 2 units, one person would be paying 50% of his neighbor's accommodation.
It's prefaced by 10.
Pardon me?
It would be prefaced by 10. It's specific, contiguously located housing consisting of 10 or more units, reasonable modification shall be at the expense of the owner. Or the condo association.
Right.
And that would not have got into, that would not.
If they put in the word in 7A, condominium, then it could imply that a condominium of 2 or 3 units, the association would have to pay. But by putting in contiguously located housing of 10 or more units, they're limiting it to only those size condominiums that are 10 or more units. And I think that was the intent of referring to contiguously located housing in that way and making a limit of 10 units. If the word condominium alone were put there, then the question would be they'd have to say condominium of 10 or more units.
Okay. Any more, Justice Smith? Okay, we're over time, so we'll have to leave it at that. Thank you. We'll hear from the association.
Good morning, Your Honor. May it please the Court. My name is Dylan Knight, and I represent White Cliffs Condominium 4 Association. We are here asking this Court to affirm the trial court's decision granting summary judgment in favor of the defendants' appellees. The trial court's decision should be affirmed for 3 independently sufficient reasons. 1, the exception to the general rule requiring a handicapped individual to pay for the reasonable modification to the premises, as defined in Massachusetts General Laws, Chapter 151B, Section 47A, does not apply to condominium associations such as White Cliffs. 2, the appellant's housing does not meet the requirements under Section 47A because it does not consist of 10 or more housing units. And 3, the appellant's unit does not meet the statutory definition of contiguously located housing. Prior to moving to the first point, I'll note that because I'll be focusing entirely on General Laws, Chapter 151B. I'll only refer to the section numbers rather than the entire citation. Starting with the first point, the exception to Section 47A does not apply to condominium associations because the language of the exception does not explicitly state that it applies to condominium associations. We've heard argument today that the entirety of Chapter 151B, including all subsections, applies to condominium associations, but that's not the case. There's specific sections and subsections of Chapter 151B that explicitly state they apply to condominium associations. And we heard earlier Section 4.6 is one of those examples, where the Massachusetts legislature noted that it made unlawful an owner of publicly assisted, multiple dwelling, or contiguously located housing, or quote, any organization of unit owners in a condominium to discriminate against any person. Here, they're specifically noting that condominium associations are subject to 4.6. Looking at the important section today, 4.7a, the legislature does not expressly extend 4.7a to apply to condominium associations. Looking at 4.7a, we can split it into 2 relevant clauses. The first clause notes that it's discriminatory, and I'll cite it in part, but it's discriminatory to refuse to permit or make, at the expense of the handicapped person, reasonable modifications of existing premises. The second clause, which we've referred to as the exception clause, is the fee-shifting provision that, if it applies, the cost of making these reasonable modifications is shifted from the handicapped individual to the owner of the premises. This clause applies where it says, provided, however, that in the case of the categories publicly assisted housing, multiple dwelling housing consisting of 10 or more units, or contiguously located housing consisting of 10 or more units. Only under those categories would the expense be made at the owner of the premises, or other persons having the right of ownership. Now, according to 4.7a, it was discussed a little bit earlier, but it's read in conjunction with 4.6 and 4.7. It describes what discrimination is in 4.6 and 4.7. So looking at sections 4.6 and looking at sections 4.7, they expressly apply to condominium associations. So it can be assumed that they also apply in Section 47A. The 47A would...
Why couldn't MCAD figure that out when they, in the Halcyon case?
The Halcyon case is not clear because it's not entirely clear what facts they ruled on with regard to the ownership of the property and with regard to, well, whether the developer was in charge of the condominium association, how many units the developer still owed. It's also slightly different because the unit owner in that case didn't purchase from the condominium association. So if the MCAD in that case is ruling that the decision is based on a purchase from the developer being binding on the condominium association, then we would say that it's ruled incorrectly. But otherwise, the facts aren't in the decision. The facts are not sufficient enough to determine exactly how they would apply here.
I mean, so you would say that I think I'm skipping your second argument now. You would say that this only applies, the contiguously located housing only applies to the original developer, if they're still selling units.
Not that it only applies to the original developer, but in this case, it wouldn't apply to the condominium association, I guess. So I guess to answer your question.
So let me just check how this works. So if Cape Side, we're back to Cape Side days, and Cape Side, and suppose Cape Side, we're in 1992 and not in 1998, because 1991 seems to be an important date in the statute. And Ms. McClellan, in sort of time warp here, comes to Cape Side and says, I want to buy this unit, but I can't access that patio. You've got to pay for it. Would that be right?
If Cape Side at that point, as the developer, as the declarant, if they met the contiguously located housing, then yes, that would apply in this case, or possibly at least. It would have to meet all of the requirements of the statute. However, focusing on 47A, I guess circling up just to conclude my first argument, 46 and 47 both apply to condominium associations. There's no dispute. But 47A specifically includes this restricting language in this exception clause, the fee shifting clause, that focuses the fee shifting, that notes that it'll only apply to the three categories of publicly assisted housing, multiple dwelling housing, and contiguously located housing. I'll note that the legislature has, when they have wanted to apply these sections of Chapter 151B to condominium associations, they have done so in sections 4.6, 4.7, 4.11, and 4.18. They all note that in addition to the three categories I just mentioned, they also apply to any organization of unit owners.
What do you say to counsel's argument that maybe those references are to condominium associations less than 10 units?
They're not references to condominium associations of less than 10 units because contiguously located housing in and of itself requires, the definition in Section 4.7a requires it to be contiguously located housing of 10 or more units. So the 10 or more units is always prefaced in the exception clause, so it will always apply to 10 or more units. Moving to the second point, even if the court does determine that this Section 4.7a does apply to condominium associations, the appellant's housing does not consist of 10 or more units. Now, looking at Section 4.7a, the exception for it to apply, and we've noted this language, but the unit in question must be in contiguously located housing consisting of 10 or more units. That's the exact language. As an initial matter, it's undisputed. The building contains 4 units. There's been argument that the court should consider all of the 22 buildings and 108 units in the entire condominium developed area, but this isn't the case. We can look at the definition of housing in Chapter 151B, Section 1. The definition of housing is any building, structure, or portion thereof. The building in this case contains 4 units. We can also look at
at 12 it says, I mean, there's a little word thrown in there. It says contiguously located housing, skipping over the offer for sale language, located on land that is contiguous. It doesn't say located in a building that is contiguous, so located on land that is contiguous.
Yes.
10 or more housing accommodations located on land that is contiguous. I mean, Condo Association 4 has 108 units on contiguous land.
Yes, but the focus, I think it's helpful to look at the regulations to interpret the statute here. So looking at the CMR regulations, 804 CMR 2.03, which we noted earlier, the MCAD notes that under state law, if the dwelling is in a building with 10 or more units. So that's the focus here, is that it's a mirror of Chapter 151B, and it demonstrates that the focus is on the building of 10 or more units.
So
Here,
I hope we don't have to talk about Chevron deference, but that's the MCAD's interpretation of this language, because I don't see the word building in there at all.
that is the MCAD's interpretation of the language, and because the appellant's unit in this case is in a building of 4 units, simply this exception of Section 4.7a does not apply.
So can I started with, I showed Attorney Jacobs those pictures, and what bothers me about those pictures is that the association decided to change the patios pretty much unilaterally, and they took away, the before picture, there's rails and steps that maybe she wasn't able to navigate in her later years, but there were some accommodation there. They leave her with not even railing. They leave her 2 steps and not even bother to put rails there.
Well, the point here is that the condominium association is only required under the statute to, under 151B, to provide to make or to allow the reasonable modification of the premises at the expense of the handicapped individual. So the condominium association can allow that, but if the handicapped individual is not going to pay that expense, there's no mandate on the condominium association to pay that expense unless the only potential fee-shifting provision is this Section 4.7a, which, again, does not apply. Moving to my third and final argument. So even if we do conclude that Section 4.7a applies to condominium associations, and even if we do conclude that all 22 buildings and 108 units count as housing, the appellant's unit does not meet the definition of contiguously located housing. Looking at the definition of contiguously located housing, it's, again, housing which is offered for sale, lease, or rent by a person who owns or at any time has owned or otherwise controls or at any time has controlled the sale of 10 or more housing accommodations. It's been admitted through stipulation of fact in this case that the appellant's unit was not for sale, lease, or rent at the time that these accommodations were requested. It's also been stipulated that the condominium association does not own, lease, or rent, and has never owned or controlled the sale, lease, or rental of any units or common areas. Yet what's been asserted is that we don't follow the strict language of the statute, that if a unit was ever offered for sale by someone who has ever owned or controlled the sale, lease, or rental by 10 units, then that would be sufficient to bring it under this exception in Chapter 151B. This simply is not practical to meet the contiguously located definition. If this interpretation were adopted, it would upend any predictability in condominium ownership. Under this theory, we could see condominium ownership be subject to unrecorded property restrictions, wherein an individual would have to buy a condominium, they would have to research whether in the history of its development and ownership, it was ever owned, leased, or rented by someone who has ever owned, leased, or rented 10 or more units. Not only does this fail to further the purpose of this statute and regulation, it creates an excessive burden on condominium ownership and buying and selling condominiums.
There are provisions in the bylaws, I think, that gives the association some power of ownership and sale control over that. Isn't that right? If there's a foreclosed unit or something like that, there are situations where the association takes over the sale.
There are theoretical situations, if there's foreclosure, that the condominium association itself could adopt some form of ownership. But
it wouldn't be. But there's no fact here that they had this for 10 or more at any time.
No, there's no indication ever that there's ever any ownership in this case, or that they had ever owned or controlled the sale of more than 10 units. And that it's actually stipulated to. It's a fact that was stipulated to in the underlying matter. But so just to conclude here, I'll also note that as my time's running low, I'll note that the MCAD regulations in Chapter 151B, they're intended to apply to housing discrimination in the context of selling, leasing, or renting. The condominium associations do not sell, lease, or rent. So for those reasons...
And that's the Colangelo case you're referring to primarily, right?
Well, I'm actually referring to the regulations themselves, 804 CMR 2.01. They literally state that that Chapter 151B and these regulations are meant to apply to housing discrimination in the context of the commerce of selling, leasing, or renting units. This is not, what we have here is not that process. So for the reasons set forth today and for the reasons in our papers, we ask this court to affirm the trial court decision, and I appreciate your time. Thank you.
Thank you both. You all did a really interesting case. Good job of representing your clients, and we'll take the cases submitted. We're going to take a brief recess. We'll be back here no more than 15 minutes to hear the last case, which is the Oak Ridge Realty case.
Court is open. Please be seated.
Thank you. I took my paper with the number on it, so bear with me a second here. Okay, the fifth case today is 23P 827 Oak Ridge Realty Trust versus Town of Lincoln Planning Board. And I don't have that. Okay, so and introduce yourself, please, because I lost that piece of paper. It's in here somewhere, but
I trust you. Good morning. My name is Attorney Timothy Angley here for the appellant.
I'm sorry, say it. Enunciate, Attorney.
Attorney Angley.
Okay.
Thank you. Good morning, Your Honors. We are here on an appeal of the action of the land court of the denial of 59E motion and denial of a motion to amend the complaint. And also there was an appellate motion to take judicial notice, which I believe was not determined either. The basis of the argument of why the case was dismissed, in my opinion, is that the focus on the court was that they were trying to make this case a matter of 48 Section 17, which would be the provisions where you need to appeal a decision of a board, like in this case, the planning board, within 20 days. And so anything that wasn't done in that time frame is going to be time barred forever. And this is a situation that happened back in the 80s. So we are making the argument that this is actually not under that provision, but rather this is under Chapter 240, Section 14A, which allows that we can challenge the bylaw itself, not any special permits that were issued under the bylaw.
Am I correct in understanding that as to the version of the complaint that the judge considered in the motion to dismiss, that all of the requests for relief involved some relief specific to your client's property?
Yes.
Is that correct?
Yes.
So it wasn't simply a declaration of, for example, the validity of the bylaw. It was a declaration that certain things could or couldn't be done to the property because of whatever your arguments were. Is that right?
Right. Yes, I would agree. And I think that argument sort of came in heavily because we were attempting to demonstrate some of the effects of the bylaw and how it affected the property, not necessarily the agreement of the permit. I come to think of it sort of as the cart before the horse and the chicken and the egg arguments of, you're saying, our argument is that the underlying bylaw itself, the enabling authority under which the permit was issued, was faulty to begin with. Starting back in 1929, the town of Lincoln didn't allow for public use on private land. So then what you have down the road is these the cluster zoning and these agreements that allowed for just that. So if the basis isn't allowed to begin with, how can you then make a change or a new bylaw that contradicts what already exists when what exists hasn't been repealed? So you still have to operate within that.
So in 1980, the argument could have been made, right?
Excuse me?
This argument could have been made in 1980. It's been the last. So when it was issued, when the developer should say, no, you can't put this restriction on me.
Right.
And they could have brought that within 20 days.
They could have, but they didn't. And because the reason it wasn't brought at that time was because you were dealing with a developer who was trying to make a profit off of the sale of the land, who was going to be agreeable to whatever terms the town was offering in exchange for their permits.
Including giving up certain rights to use of the land.
Right. It's not necessarily a voluntary situation, as you know. Sometimes when you're negotiating with towns, it's all right if you want to build an extra unit, you're going to give us this.
So, but how does this not come around to saying that the special permit shouldn't have been granted?
I think that what we're saying here is that the basis of the enabling clause was wrong to begin with. So the fact that they went and issued permits off of the faulty base structure is a consequence of the fact that the bylaw itself was in error, and in our opinion, still remains in error. So to demonstrate some of the effects of what happens down the road and sort of bring in the arguments, which is sort of like the constitutional arguments and the fact that you still can't have public use on private lands, we demonstrated and we talked about that the walking trails were originally intended to be sort of for the town of Lincoln and then expand to the Commonwealth. And now it's sort of would include everybody in the world. And
well,
so
that move I get, because the town can't have a public land that's just for the town. The public land has to be for the public.
Right.
I get that's why it's the whole Commonwealth and not just the town of Lincoln.
Right, and I think that because we're demonstrating this is sort of what happens along the way, but the basis for allowing this to happen goes back to that original argument that the bylaw itself shouldn't have been allowed in the way it was. And Section 14A allows us to bring this argument 30 years later which was initiated and sort of triggered by one of the neighbors saying, or implying that they were looking to be agreeable with the town and even expanding the walking trails. Now, this person may not have had the authority to actually do that, but it sort of indicates to my client that, look, you're going to, when is enough, and it's going to become this integrated system of trails throughout the land that shouldn't be there to begin with, and because this public use shouldn't be allowed from the bylaw.
This may be totally irrelevant, but since you begin with this Jane Herlocker from the Brooks Hill Homeowners Association in your brief, what is the Brooks Hill Homeowners Association, and are your clients members of it?
Yes, it's the association is all the landowners. Sort of, it's a regular homeowners association. Because Brooks Hill Road is a private way, so they have to maintain the plowing, road maintenance, some of the other things, and they
probably got to keep it accessible too.
Right, exactly. And so they in the original set aside this open space land, which is several acres, and has frontage along Brooks Hill Road, so that there's access to this land. That if you were gonna make that public gathering area or whatnot, there was the ability to get there, and they didn't need to do all the easements that have now turned into trails, which have turned into just expanded public use, which we highlight as an example of that it's not just a matter of my client being irritated someone walks their dog on the property. It's turned into almost like I said, a public trail system that was way beyond the scope of whatever should have been contemplated and would normally be found in a cluster zoning community. When you're building something nowadays and you agree that you can put in an extra 5 units as long as you set aside some acreage, that acreage isn't generally for the public to come on, it's for the community, for those houses there in that community to be able to use as open space.
In the other side's brief, they comment about a finding that was made by the judge about just what we're talking about here, and I think your argument is consistent with it today. There's a finding that it's on the docket at Record Appendix 116, page 16, that the sole claim raised in the operative complaint is the 14A claim.
Right.
And that all the other arguments, and you've said it here, were sort of like examples of what flows from it. So, but we're dealing with the 240 14A claim.
I'm sorry, what was the question?
We're dealing with the 240 14A
Yes.
claim. That's what's before us.
Yes, that's because that is the action that is not time barred at this point, and the basic argument, and it perhaps should have been better fleshed out and more focused in some of the pleadings that came prior, is that the underlying enabling clause shouldn't have been there to begin with to allow this cluster zoning, to allow these easements being put on.
So, I mean, isn't the purpose of 14A to test the validity of the extent of a bylaw? For example, if you are now a developer and you're trying to do a cluster development, and you look at 6.6, court, tell the town that they can't require public land now, and I can do this development, and that provision is invalid. And
Right.
presumably the judge would say, presumably, it seems, I don't think anybody disagrees that yes, that's invalid. So it's a taking. It's not correct.
Yes.
But we could say, yeah, 66A, section 6.6 is invalid, but then what? I mean, then you're saying, then what? Suppose that was the ruling. Then what? How does that affect your client's deed?
What my client would be looking to try and do is be able to have the easement on their property lifted, because
I'm saying the one that's on the books, it's been on the books since 1980 or 82 or 86,
Yes.
is invalid.
yes. And I think that, as I mentioned before, the open space that the developer designating and gave to the town has access by the public, if that's what was really intended. So there's no need to go around on the back end to access this area that sits over with frontage on the road, that you could put parking spaces and make it a park if you really wanted to. You didn't need to go this way. And because the statute itself allows us to come along 30 years later and say, hey, this shouldn't have been allowed, and the fact that the special permit wasn't recorded until after the property had been sold off by the original developer, you're dealing with an issue too where did they really have the right to be able to impose the easement on the property to begin with, which is another consideration here of that you should have properly recorded it, and therefore owners should have known that this was a restriction that was coming in, as it was.
Recall whether there's a citation in your brief to a case that specifically says that a failure to record has the effect that you argue. Is there one? Am I just,
Off the top of my head, I can't recall, but the statute itself, I believe, says that in order for it to be valid, I think it's 48 Section 10, says it has to be recorded in order for it to take effect. We recognize that it was signed off by the clerk and by the planning board at the time, yes, but the sort of goes back to the whole idea that because you didn't follow the procedures you were supposed to do, anybody who was buying at that time wouldn't necessarily be aware that there was a restriction on the deed and there was an easement going to be placed on, which again came back from the original idea that this shouldn't have been allowed to exist.
But the argument, no one's made the argument that there was no notice, that they lacked notice and therefore depended on the lack of notice.
Right, and I don't know if we can make that argument now because we came along and bought the property after this had already occurred.
So why doesn't the Whitensville case govern here that says, the evil to be remedied is a situation where someone may be forced to invest in land and then subsequently find out there are restrictions? No such situation exists here.
I honestly don't have an answer for that right now, but what I would say is that the fact that there's a restriction on the property that exists now, we're not precluded from being able to come and make that argument, and I think that was in the Lopes versus Peabody case that even though there's a restriction, you can come along and challenge it later on, which would be this case. And it may not have been an issue that would have even been litigated if not for the association saying that we may now expand the trails and whatnot. It may have been a matter of being able to let it lie until it became an issue that was going to exasperate or potentially exacerbate the existing conditions and situation on the ground.
Could I just ask a couple of isolated questions? They're going to jump around a little bit, but
Sure.
You make an objection, I think. You argue that there was a problem with the judge's consideration of this motion as a motion to dismiss, which was how it was originally filed, but the judge had expressed some thought that it was going to be addressed as a summary judgment issue instead. Was the judge's ultimate determination of the motion as a motion to dismiss something that was objected to at the time? Is that a preserved
I believe so.
issue? Where can I find it?
I don't know, but I believe that that was the, I may not have been the one who made the argument. It might have been my co-counsel, Mark O'Brien.
Okay. And the question about the argument about a discrepancy between the trust's property's tax classification, was that something that was preserved in the trial court?
I believe that was mentioned, yes, because the way that the tax law is written, it says that only 61A can be, land that's in 61A can be used as public land, as private land be used publicly.
You know where in the record that is?
I don't, off the top of my head.
In the hearing, or was it in papers?
I think it was probably in papers.
And with respect to the Rule 59 motion, I have a question about the timeliness of the filing there, which I don't think anybody's raised. I'm just unclear looking at the papers. Was that motion filed within 10 days of the judgment?
I'm not 100% clear. I think so, but
I understand that I'm asking very specific questions.
Yeah,
without giving much warning about them. So
yeah. I honestly I can't off the top of my head recall.
okay, thanks.
Okay, well, rest on our motion. Thank you.
We'll hear from the town.
Good morning, Your Honors, and may it please the Court. My name is Devin Braun. With me is Joel Bard, and together we represent the Planning Board for the Town of Lincoln. The town is asking this court to affirm the land court's decision based on the well-established case law applicable here. And I'll begin with the Chapter 40A, Section 17 claim, because that's the primary basis upon which the appellant's 40-year challenge, too late challenge to a special permit condition fails. Section 17's plain language requires that a person aggrieved by a decision of a special permit granting authority or a local board of appeals bring that claim within 20 days of the decision being filed with the office of the city or town clerk. Here, it's undisputed in the record that the special permit was filed with the town clerk on November 20th of 1980, and that no appeal was ever filed within the 20-day window or by December 11th, 1980. That's in the Record Appendix, Volume 1 at page 54. The SJC plainly held in Iodice versus City of Newton, a case which is dispositive to this appeal, that the failure to file an appeal within that 20-day window is a complete jurisdictional bar. And this is true even if the appellant or plaintiff frames their claim not as a Section 17 claim, but as a claim for declaratory judgment or some other independent challenge to the underlying decision. Now, in Iodice, it was a Chapter 231 declaratory judgment claim, but the same reasoning applies here to a Chapter 240, Section 14A claim. And this is because the legislature, this complete 20-day bar is because the legislature intended that landowners, abutters, members of the public, anyone who needs to make land use decisions and investments in their property be able to rely on the fact that no challenge has been brought within that limited window. And in this case, the members of the public, the other 8 owners of the subdivision, the 8 lots of the subdivision, the Brooks Hill condominium, or the Brooks Hill subdivision, have all relied on and used these recreational trail easements for the past 40 years.
Does an entity, an owner in the position of the trust, have any recourse if the bylaw is in fact invalid?
The recourse would be back in 1980 for the original developer to have challenged that condition if they thought that it was unconstitutional or invalid at the time, or if it's the trust currently, it would be not to acquire that property when they saw it on record when they purchased it in 2017. The reason
I just wanted to test this a little bit more. That you also include in your brief the statute of limitations for a taking claim, right? There's one of those as well, which is longer than 20 days.
3 years.
3 years.
3 years.
So suppose in 1983 they'd brought a claim. You know, it's sideways challenging the special permit, but this was a taking without just compensation. Would that be barred by, under like IDIC?
If the trust brought the claim or if the initial developer brought the claim?
Well, I guess the developer, let's say.
If the initial developer had brought a takings claim within the 3 years, I don't know that there's,
Are they challenging
whether that would be barred within the 20-day. If the underlying claim, is to the constitutionality of a special permit condition, any collateral appeal, I think that's been clear in the Klein and the Bonfatti cases out of this court since then, that regardless of its form, a challenge that circles back to the underlying condition itself is in effect an appeal of that special permit condition. And so for that reason, under the Section 17 claim, Oak Ridge's third amended complaint, which is the operative pleading before the land court below, it sought a binding declaration that that special permit condition was invalid. And it's, regardless of the numerous ways in which it frames its claims, it's essentially an appeal of that condition, and it's been brought 40 years too late. And turning to the appellant's contention that its sole claim is brought under 240 Section 14A, Your Honors, the plaintiff cannot circumvent the exclusive remedy that Section 17 provides by framing their challenge as one to either the underlying zoning bylaw or any other declaration regarding the cluster bylaw at issue. This is because Section 14A, by its plain terms, permits a party to challenge a municipal zoning bylaw, an ordinance, a regulation, and as an initial matter, to challenge a town's zoning bylaw, you have to bring the claim against the city or town in which that land lies. Here, the town of Lincoln was never named as a party, and the planning board is not a proper party to defend the validity of a town law.
Although I did notice that in your brief, when you're requesting appellate fees, that you request that we award the town its fees. You don't say planning board, even though you say the town's not here.
It's true, but meaning the town who will essentially pay the fees as the limited municipal entity, the taxpayer funds of the town to pay the attorney's fees. But it is solely a claim against the planning board, Your Honor. And even if the town had been named as a party, the statute applies only to a determination of the validity of the zoning bylaw, not the validity of a special permit condition or the validity of the covenant executed thereunder or the validity of the trail easement recorded pursuant to that condition. And the SJC has already concluded, as Your Honor pointed out in Whitensville, that Section 14A doesn't confer authority to interpret the effect of a special permit. You can't use Chapter 240A to sidestep a zoning appeal.
You explained in the brief, but maybe you could do it. It might be helpful for me to hear it. How the Whitensville distinguishes Banker Realty, which sort of does allow a challenge to something to go forward under 14A. What is the difference?
Under Banker.
The extent of the bylaw.
Yes, Your Honor. So under Banker Realty was sort of the case where the court said, it's not just a challenge to the validity of the bylaw itself, it can also be the extent of how that bylaw is applied to a property. In this case, it was the Boston zoning code. And it was a challenge to how the building inspector interpreted the zoning code as applied to that person's property and whether they could appeal under that extent line of cases. This case doesn't involve any interpretation of a zoning bylaw. It involves a special permit condition. And to that effect, even if it were an interpretation of the underlying cluster bylaw, zoning bylaw, the statute doesn't apply retroactively to have invalidated it in 1980. At the time, it only applies to sort of present or future uses of land because the purpose is to prevent a landowner from, is to get a declaratory judgment without any actual controversy so that a landowner can not be forced to invest in land and realize the restriction applied in some way. Obviously, in this case, where Oak Ridge acquired the property in 2017 on full notice of the easements and the restrictions that were applicable to its property. That line of reasoning doesn't apply.
Can a party under 14A challenge a bylaw like in the abstract, or does there have to be an as-applied thing? Does there have to be some sort of case or controversy where they're saying it's going to affect me somehow?
Yes, you can. There doesn't have to be a case or controversy, but it does have to affect the person's land. If you're going to challenge someone else's use of your land, it has to affect you. There is like a minimal standing. There is a minimal standing requirement, though. The SJC has stated that standing is a relative misnomer in that context. But in using the remainder of my time, I just note that any challenge to the cluster bylaw, again, IODIC, the Sergey case, Klein, they all state that any attack on the bylaw, the underlying validity of the bylaw itself, is essentially an attempt to sidestep the appeal, and the developer, if they had an issue with the constitutionality of the bylaw, could have raised that challenge themselves. I believe I heard appellant's counsel say that they were not raising any claims other than the 240-14A, but just to briefly address the references to spot zoning and takings claim and the like, it would just, and for spot zoning, the lot in question is, again, subject to a special permit. There was no rezoning of property. There was no singling out of property for zoning, and the concept is inapplicable to the facts at hand. Under the tax classification statutes, the appellant didn't point to any private cause of action that I think would allow it to bring such a claim. And I do believe the record suggests that all of these ancillary claims were waived below when the appellant's counsel stated that it's, quote, sole claim, unquote. That's in the record, volume 1 at 16 was the 240-14A claim. So they raised them in the papers, but I think appellant's counsel conceded that it was just to show some of the effects that the property owner was experiencing and not true legal claims. But in any event, the court should reject any cursory reference to waived claims or undeveloped legal theory that don't rise to the level of appellate argument. Finally, I would just note that the motion to amend the judgment or to amend the complaint post-judgment were properly addressed to the discretion, considerable discretion of the trial court, who was in the best position, knowing the procedural history of the case, to determine, and that ruling shouldn't be disturbed except upon a clearing of a showing of a clear abuse of discretion. Here, the facts and the legal theories have all remained unchanged since 1980. Any other amendments would have been futile, and the judge appropriately determined as much. I would just finally ask that the court reject Oak Ridge's request for any attorney's fees. They were not requested in the court below and were waived. And Oak Ridge was not the prevailing party below, so it would be improper in any event. But I do submit, Your Honors, that this is one of the rare cases, circumstances in which the planning board is entitled to an award of its attorney's fees because the appeal is insubstantial based on the well-established case law in this area, and I would reserve that right on behalf of the board. In short, unless Your Honor have any further questions, however Oak Ridge characterizes its claims are really challenges to the special permit that were brought 40 years too late, and the sound judgment of the land court and thorough, well-reasoned decision should be affirmed. Thank you.
Okay, well, thank you. The case is submitted, and that'll conclude today's sitting. I want to thank the court officers and the excellent job for the clerk, and we'll be in recess.